was going to ask you about Burt Jenner.
So Burt Jenner was a litigator of a very different style than John. John, as I mentioned, was fade into the background, let the witnesses be the focus of the jury's attention. They had both tried a lot of jury cases. I had not tried jury cases, but they had tried jury cases. Burt Jenner wore, one of his trademarks was very brightly colored socks. And I think he used to get, John had told me at one point that he used to get John a little slightly aggravated because Burt would turn to Bernie Nussbaum. And he would say, and with John in the room, and say, now Bernie, you and I are litigators. Sort of inferentially that John wasn't a litigator. But Burt was an absolute straight arrow kind of guy, you know, he was not for distorting the process. He was for, you know, letting the cards fall where they did, letting that needle end up wherever it ended up. He didn't work as hard as the rest of us because his life just was the way it was. He lived in the Madison Hotel, and we all lived in these, you know, little heavily furnished apartments. I forget where John lived, but John did not live in the Madison Hotel. Burt was larger than life. Burt was extremely likable, very friendly, would invite you over, very nice guy, and no doubt a giant of the bar, no doubt. You know, just a founder of a really great law firm. So I can see why he would turn to Bernie and say, "You and I are litigators." John from Wisconsin, you know, it was a little bit different. But that was Burt. But I wanted to mention one thing that as this needle is progressing to where is there a case or not for impeachment. Two things that were important for me, and I think for others as well. One is the misuse of the concept of national security, which is very, you know, important and legitimate. And I can accept doing extreme things whose legality might otherwise be questionable in the name of national security. National security is a real thing that's important to the country, and obviously it was important then, is totally important today with all the threats we're under. And therefore to use falsely national security as a cover seemed to me a compounding problem, a compounding reason to find subversion of the Constitution. I'm not sure we ever focused on it too much, but I think we did. I think we certainly pointed to the, and the staff was all totally, we had this thing where when we were initially listening to one of the tapes, somebody had written down Earl Nash. They had heard Earl Nash. And it was, in fact, the president was saying national security. And so national security was always this thing that was being used. And it was, you know, it was a problem that you would use national security as a cover for things that didn't have anything to do with national security. The other is, again, this is a big picture item, but overall indifference to the legality. Overall indifference to the legality. So one thing, you know, we concluded, we not only concluded there was a cover-up, John ultimately concluded, stated that he had concluded that there was circumstantial evidence the president had authorized an illegal surveillance program, the Watergate of which the Watergate itself was part. Not that the president knew the particulars of who was hired and this and that, what night they were going in, but he had authorized a intelligence, inferential, circumstantial evidence of the kind you described. But part of one piece of the circumstantial evidence was this indifference you found in other areas to what the law was, to whether it was legal or not legal, whether it was obstruction of justice or not obstruction of justice, whether it was proper or not proper from a legal point of view. And so that obviously then ties to the, it's a compounding fact for finding a constitutional high crime misdemeanor, given up, because it relates directly to the duty to take care that the laws be faithfully executed. And so it's one of those things, some people might say, well, that's a higher standard for a president than would be applied in a criminal court, but indifference to legality is a particular problem for a president in terms of his role under the Constitution, or her role under the Constitution. So those were some things that, in my mind, pushed the needle forward.
Did the information from the White House prove useful in pushing the needle forward?
Yes, because of the differences in their transcripts from what was really on the transcripts.
I was also going to mention the political matters materials,
right.
memoranda that Gordon Strachan wrote.
Right. I did not use those as much as those working in areas like the plumbers, Ellsberg, Dick Gill. So I did not have as much, I don't recall poring over those memoranda at all. I don't recall using them in a significant way. I think others may have, but I don't recall them being a factor for me.
In the final report, the staff, and I suspect it may have been you, the staff makes a point, I'm not a lawyer, so I'm probably going to get this wrong, but the president kept making a case for protecting something for because it was not relevant to Watergate in the tapes, in the transcripts that he released. And then when you listen to the tapes, you recognize that there were sections that he'd said were not relevant that turned out to be relevant. So it wasn't just an issue of their transcriptions being perhaps questionable, but it was also the deletions themselves seemed indicative of a continuing cover-up.
Right.
And you may, in the footnotes at least, in your report, you refer to this over and over again as part of a pattern.
But I remember the report was more of a committee product because it was the last thing that was written, and the committee was heavily involved, whereas the statements of information, John's statement to the committee at the end of the presentation of information was more of the staff product. I remember a book of focusing on 8 transcripts that the staff prepared and put out. And my I have not read it recently, but many years I haven't read it. I don't think I have a copy, but my recollection, it had both elements that you're talking about. It had things that were deleted, but it also had phraseology changes that were important and material that were wrong. And I also recall having some reason to think, and I don't recall now what the details were, but that this was not just the lawyers putting together these transcripts, but the president himself being actively involved in the process of reviewing the transcripts, deciding what would be presented. And I can't recall why we thought that, but I remember that, so that it was not just a lawyer's call, but that he had been involved. And I think it was a powerful piece of information for the public, for the committee. And what's persuasive to the public is relevant. That's the part of the thing, right, that's a political process, because it has to be something where the public feels that this extraordinary step is justified. And so that's where the committee is making a judgment about what the public, how the public will react.
Do you remember the pressure on Mr. Doar to express his opinion?
It's something that I've been reminded of recently by talking to John, because I have talked to John in thinking about this, and he reminded me that he had been pressured to express his opinion, and he told me that he understands Francis O'Brien, has said that he was part of doing that, and John didn't deny that that was the case, and that John should express an opinion. And so in preparing for this, I did reread his statement at the end there, and it certainly expresses an opinion.
But he didn't want to do that initially.
He felt that the committee was really strong, that all this was their decision. And you notice when he starts to express his opinion, there's some committee members who start to interrupt a little bit, and where's the citation for this and for that? It was not totally, I gather, I didn't go back and look at St. Clair, but from the comments that are made objecting to the objectors, that when St. Clair spoke, nobody interrupted him. But I think John felt strongly the committee did not want the staff or John or anyone reaching a conclusion for them. But he ultimately, so during the process, he did not express opinions. We had this putting a record before the committee approach. Then he expressed an opinion, and then he obviously supported the articles that were drafted to put before the committee, and which they voted on.
Bill Weld said he knows that there was an attempt to put Republicans in most of the task force to keep a sense of bipartisanship. But he wasn't sure if there were any Republicans who worked on the issue of the cover-up and obstruction of justice. Were there any?
There were, and as I said, my recollection is that there was also a Republican on this tape group, but in the group that I was working with, there were a couple of Republican members, and it wasn't always that obvious who was Republican and who was Democrat. But I think Jared Stamel was Republican, I think. I think there was another guy, blonde hair. What was his name? It's hard to remember all these names.
Now, were you their supervisor?
Yes.
And who did you report to?
I would say I reported to a combination of Dick Case and John and Joe. Maybe Joe Woods, although Joe was very heavily involved. The reporting lines were not very clear on the impeachment inquiry. I remember Bernie being involved in most everything. I certainly talked to Bernie. So the official senior lawyers were Bernie, Joe Woods, and I think Dick Cates. Is that your recollection? Dick Cates, Bernie, Joe Woods. They were the John,
Yes.
Bert Jenner, and then the next level down, senior associate counsels, Bernie, Joe. And I can remember meetings involving all of them. So it's not really too clear who I reported to. I would, I think I was a provider of information and analysis, and Fred Altshuler, you're going to talk to him at some point, I hope, out in California. He was very instrumental in writing up statements of information and doing things, using some of the stuff that developed, and I certainly didn't view him as a subordinate or anything like that. The thing I supervised was a group of quite younger people, although Bob Traynor was one of them, and he wasn't that young, who were really working through the materials. And we had this process of filling out chronology cards. And chronology cards, they have the advantage of forcing you to really focus and read carefully. Because you had to read it and make a card about a meeting. And you had to have a card then for each participant in the meeting about what they said happened in the meeting. So it was very good for focus. I can't say that I remember taking a lot of time and going back and using the cards as an original resource, because by that time I knew the key meetings, 30 key meetings, something like that. I knew everyone who had been at the 30 key meetings. I knew from my memory what they had said and where I could find what they had said. But having everyone do the cards was a very good source. And then just like the tapes, another good advantage of this is that everything gets checked by so many different eyes that overstatement or misstatement, worse, is eliminated. And we did not want overstatement. And this is something I continue to do litigating today, because overstatement just gets you into trouble. And we wanted an objective view. So I do today, and lawyers do today, a lot of internal investigations where we're hired by companies to find out what happened and then to report to them on what happened. And this is somewhat similar in that typically we would start by looking at documents, looking at prior testimony in an internal investigation. This did that. We would then go on to ask witnesses about the documents and about prior testimony. We did that. And it generally involves a big team of lawyers doing it. And one of the reasons for the big is there's some duplication in it, but it leads to the multiple eyes coming up with both accuracy and things that otherwise might be missed.
When you helped decide what the committee would request, the subpoenas, how confident were you that you'd get anything?
Well, I don't. I can't remember exactly what I thought then. I don't think we necessarily thought we were going to get a whole lot. I think we thought we would get something, but we didn't get everything we asked for by any stretch. And there was an article of impeachment based on, refusing to honor the subpoenas. So I can tell you one story though about subpoenas. So very early on, John and the committee, and I think the chairman. I did not deal with the chairman the way John did, Peter Rodino, but I think it was early on decided that there would be no effort to seek judicial enforcement of our subpoenas the way the special prosecutor did, and that so we never went to court to enforce the subpoenas. Although people said, well, "Why don't you go before Judge Sirica? He will definitely enforce the subpoena." But we didn't do that. And one day I got a call, and Potter Stewart invited me to lunch, and he also invited one of my co-clerks at the time, Tom Rowe. And so that was really nice because he knew I was in Washington, and you know, the Supreme Court was not far away from where we were, and so it was very nice to have lunch with Potter, and most of the lunch was just, you know, but I do remember at some point during the lunch, he made a statement about the unwisdom of asking the court to any court to become involved. My recollection is the way he put it, you know, once they ask the court to enforce something, they decide the rules. They decide what they're going to enforce. They decide this and that. And so it is an impairment of the prerogatives of Congress under the Constitution with respect to impeachment, because the courts will not just blindly sign a blank check for what you want. They want even more justifications than we gave to the committee. So we had already decided not to do that, but I thought it was interesting that this was before Nixon, the special prosecutor case, United States versus Nixon. And that, of course, was different in that enforcement of the law in a criminal context is a high priority for a court, a higher priority for them than a congressional impeachment. And so the special prosecutor get the benefit of it being in the executive branch himself and enforcing the law. And of course, they were the ones who came up with the June 23rd date.
Two questions. One, what was Mr. Doar's response when you told him about your lunch with Potter Stewart?
I never told him. Because we had already decided not to do that.
But the Supreme Court didn't know that at the time.
The Supreme Court didn't know that, but John didn't need to know because he wasn't going to do anything.
No, but what I'm saying is that Potter Stewart, when he
Stewart
didn't know.
He didn't know that we might go to Judge Sirica and...
because at this point, the subpoenas had already been issued, correct?
The subpoenas had already been issued, and I believe, if my memory is correct, there have been issues about compliance.
That's fascinating. And the second question I have to ask you about is Garrison. Did you ever interact with Sam Garrison?
Obviously, you know, he was there. We would interact a little bit. I don't think he viewed me as, you know, a big central. I was this worker bee, you know, down there doing this little task force of people, you know, assembling materials. And, so I didn't interact with Sam a lot. I remember, in general, you know, people became unhappy with Burt Jenner, and Sam's role increased, and
people became. I thought it was just the
Republican committee members became unhappy with Burt, and thought he was not being, you know, sufficiently telling the other side of the story. I think. I remember Sam's role increased. I don't remember any particulars, though, of what that involved.
Back to the Supreme Court issue for a minute. Was there ever any consideration of waiting for the Supreme Court to rule? Because you knew that one of the things they were going to rule on was the June 23rd, 1972 tape.
There was no option to wait any longer. We just worn out the... So when John spoke, as I mentioned, I did reread that. And it was nice because he talks about the 100 of us and how this is the product of all 100, which is true, maybe not all 100, but, you know, it is a very, and he talks about 6.5 months that we've been doing it. And 6.5 months was all we were going to get.
What was the feeling before the vote on Article 1? Was there a sense that there would be a bipartisan majority?
Yes, I think that we either from discussions that people had with various members, there was a sense. I think the members were quite active in the drafting of the articles, and I have the recollection that you could tell from who was participating and helping to draft which article, who was going to vote for it. And I remember feeling at that point that there would be, because of the people participating, there was going to be bipartisan support.
How did you feel? How do you remember feeling after 3 articles were approved by the committee?
The strongest feeling throughout this process is the feeling that isn't it amazing that you're involved in this historic process, but you can't work up a sense of total momentousness because you're so busy dealing with the day-to-day details of an historic process. But definitely it was awesome to be involved in the historic process. It was awesome to be a Supreme Court law clerk with all these big cases. And so I remember the feeling that this was a moment in history very strongly, but I don't remember being able to appreciate that feeling because there was so much to do, to dwell on it or to enjoy it.
Where were you, and do you remember when you heard that President Nixon was resigning?
Yes, I was. I had taken a vacation with my girlfriend. We'd gone to a little, hotel resort kind of thing in West Virginia, and we're driving back to Washington. And it was on the highway, and I heard that he had resigned. And I didn't have any expectation that I recall about how it came out, but I recall distinctly saying that I thought that was a good decision to give him a pardon. Resigned. Resigned. That I don't recall. I was talking about pardon. Resigned. I was not surprised. The tapes had come out. He had no support. It just seemed, inevitable. I don't recall feeling a sense of relief or elation, but it just seemed to be that, like I would feel now if the articles of impeachment had been voted on a bipartisan basis and further evidence come out and the judge signs the order officially making it a done deal. I felt that way. I know we were, I was not thinking about having a trial in the Senate or anything like that. And I think it was because I felt that he was going to resign, that it was just not going to be sustainable, particularly after the Supreme Court decision and then the content of the tapes.
Had the president not resigned, that summer at least, what were you planning to do? Were you going to stay with the inquiry, or was the staff actually dissolving?
I would have stayed. I would have had to stay. You can't build up all that knowledge and then say, oops, thunder.
Yes.
That the country doesn't need you. I mean, it's sort of an obligation to stay. But again, I don't recall thinking that was really going to happen after the point of the tapes and the committee becoming unanimous and being obvious that articles of impeachment would be voted. And we'd done so much work on all the facts and all the information that I don't feel we would have been scrambling, to present a case had it come to that. But
what was it?
I know that what.
No, go ahead.
When I've done cases here at Cleary when I was a younger lawyer, suddenly I would notice that the senior partner would lose interest in the case because they would know how it was going to come out at that point. This wasn't quite that, but it really became, as I recall, fairly clear.
But did your senior partner lose interest? Did he think it was going to end? I'm talking about
John Doar?
Yeah.
I don't know the answer. But I think I did.
So you didn't, because was the staff's intended to continue?
We were all intact at the time of the resignation. I was in the building, in my office, at the time of the resignation. Time of the pardon is different. That's what I was telling about. I'd gone away. But at the time of the resignation, I was there, and I think everybody else was there. And then the resignation was like August
8th, effective the next day.
August 8th. And I stayed until maybe towards the end of September, something like that. And in the period after August 8th, the staff did unwind pretty quickly.
Yeah, he resigned on TV August 8th.
Right.
Left
the
midday.
Helicopter, right.
August 9th was the helicopter
right.
departure. Have we missed any anecdotes?
So I told you about the pardon. I thought the pardon was good. I remember thinking in my mind that it made no sense and was not dignified for a former president to be making mattresses in some penitentiary. It just seemed to me wrong.
It's striking how close many of the members of the staff remained. There was what was it about the climate of 1974 Washington that annealed the staff together, that brought you together so strongly?
Isolation. We couldn't talk to the press, friends. We couldn't talk about what was going on. Judges become very close to their law clerks because of the same isolation. We all became very close to one another. We all ate together all the time. No one had any social life. A unique experience that we all shared of this whole process that really no one else knew about or could easily be explained. I think that I changed my attitudes about certain things, hopefully, unrelated to the topic of the impeachment. For instance, I had worked at a Wall Street law firm and hadn't really liked it because it seemed very dull. But on the other hand, the impeachment, I met these Wall Street type lawyers who were not a bit dull, like Bernie and Bob, and then other characters like Dick and Fred and the others, and it gave me a new respect for the private practice of law, which I'd not been. I was sort of on the road to being a permanent, consumer protection division kind of guy. But I decided, to see if I could find a way to both do things in government and be part of the private practice of law, because these people changed my mind about what it meant to be in private practice.